Substantive regulations. Substantive regulations are laws and rules that govern or oversee how we behave as real estate agents. In order to keep our license for longer than 5 minutes, we must always perform within the letter of the law. The following slides will detail. Lawful real estate practice for licensees. Completing a listing, sales, or leasing contract whose form has been prepared by attorneys. So we are required as licensed real estate agents, the forms that we use in transactions have to be forms that have been prepared by attorneys. Completion of such legal forms or written offers to contract by licensees must include a description of the property, a method of payment, any special stipulations or addenda required, and any dates necessary to determine if the parties have acted timely in meeting their responsibilities under lease, offer, or contract. Well, time is of the essence, okay? That may be something you've heard before, but time is of the essence. When there are timestamps in your contract, be it due diligence, be a start and end date, be an offer expiration date, we must stay within those time frames, okay? It is very important that you include a description of the property and sales contracts, as well as listing agreements and leasing documents as well, okay? Any special stipulations, a special stipulation would be something to the effect of property must be sanitized by a professional cleaning service prior to final walkthrough. That could be a special stipulation. Or another example of a special stipulation would be that the seller has agreed to purchase a home warranty for 1 year, not more than $600 for the buyer. That would be a special stipulation. If a date necessary to determine if the parties have acted timely. Let's say on your offer, your purchase and sale contract, that you have a 21-day finance contingency agreement, which means that the buyer has to get final loan approval within 21 days of binding. All of those things are a part of the legal documents that real estate agents deal with on a day-to-day basis. A Georgia real estate broker may pay a referral fee to a broker in Georgia or an out-of-state broker who refers a prospect to a Georgia licensee, as well as collect a referral fee from the Georgia broker or an out-of-state broker for referring a prospect to another broker. I just talked a moment ago and gave an example of being a Metro Atlanta broker, referring a prospective buyer or seller to someone, a real estate agent in Valdosta, Georgia. Well, the brokers have to agree. Whenever you're doing a referral, you need to consult with your broker. You need to consult with your broker. Your broker is responsible for paying you that referral fee once that fee has been received from the other in-state broker or even an out-of-state broker. So it's very important to have those conversations with your broker if you intend to refer business outside of the brokerage. Non-resident licensees. A person who resides in another state may apply and receive a Georgia real estate license if that person meets the requirements for licensure required of Georgia residents. So even if that person, all the time folks are, from Florida or South Carolina, the surrounding states, Alabama, may contact someone to say, hey, I would like to get my license in Georgia. I'm a licensed agent in the state of Alabama, for example. That Alabama resident licensee must meet the minimum requirements, the same as anyone else in the state of Georgia. A non-resident applicant who is not a broker must be affiliated with a resident or non-resident broker license in Georgia. So that person, for example, I use Alabama, that Alabama licensee must be affiliated with a broker in Georgia, because who pays them? Their broker, okay? So They have to be able to be paid and put their non-resident license with a licensed broker in the state of Georgia. At the same time, the Georgia real estate broker and the Alabama real estate broker would need to communicate, okay? Because the Georgia broker will be responsible for any transaction that Alabama non-resident licensee has in the state of Georgia. Non-resident brokers who wish to do business in Georgia but do not hold a Georgia license may do so through a written agreement with a Georgia broker who shall be responsible for all real estate brokerage actions of the out-of-state broker. Absent a non-resident license in Georgia, a licensee from another state may still conduct real estate business in Georgia if that person first signs an affiliation agreement with a Georgia broker who agrees to be responsible for the transaction in which the non-resident participates. Separate agreements are required for any additional transaction in which that non-resident participates. So for each transaction, if you're a non-resident licensee, for each transaction that takes place in Georgia under your Georgia affiliated broker, you would have to sign an affiliated agreement for each transaction. There's no blanket document that will allow you to have multiple transactions. Each transaction requires that affiliated agreement with your Georgia broker. States whose educational requirements for licensure are similar to Georgia may have reciprocity agreements with the Georgia Real Estate Commission. As such, those applicants who hold out-of-state licenses may be exempt from the Georgia education and state exam requirements. Georgia allows real estate license reciprocity with every state in the U.S. except for Florida. With Florida, we have mutual agreements. Reciprocity means you don't have to take all of your pre-licensing education hours again. Depending on the state, you may need to take the full licensing exam or part of it. Taking your pre-licensing education in another state usually satisfies Georgia's educational requirements. On the other hand, in Florida, where there is a mutual agreement between the two states, Florida residents are required to take and pass the Georgia portion of the real estate licensing exam for both broker and real estate. So Florida has mutual agreement, and most other states has reciprocity. Brokerage form licensure. The commission issues a brokerage firm 2 licenses, one in the name of the firm and the other in the name of the qualifying broker. A brokerage firm may only do business in whatever name the firm license was issued. Licensed salespersons may only perform brokerage activity in the name of the brokerage firm with which they are affiliated. So if you are a licensed agent, and you place your license with XYZ Realty, then all of the business transactions that you have would belong to XYZ Realty if that is the name that your brokerage firm is doing business in, okay? Designation of qualifying brokers subject to firm business organization. Well, as a broker, as a brokerage, you could have different types of business organizations. You can be a sole proprietor, you can have a partnership, you could be a corporation, okay? So sole proprietorship, entirely owned by the qualifying broker. Partnership, qualifying broker must be the general partner. A corporation, qualifying must be officer of corporation. In a limited liability firm, qualifying broker must be a member or manager of the LLC. Now, you can also get these things or establish business organizations as salespersons as well. I know quite a few agents that start their own LLCs or partnerships once they become licensed. When a firm loses its qualifying broker, The firm must secure a new qualifying broker within 60 days. Brokerage firm management oversight. Each brokerage firm must be under the direct management and supervision of a qualifying broker, responsible for oversight activities that include ensuring that all licensee affiliates have written affiliation agreements with the firm that identifies licensee's affiliation status with brokerage firm as independent contractor or employee, as well as reviewing compensation structures for affiliates. And what that's simply saying is that when you become a licensed agent and you've selected your broker, your broker has completed a sponsorship form saying that once you get your license, that license will be placed or hung at the broker of your choice. Well, when you meet with your broker will most probably have you sign an affiliation agreement with that brokerage that identifies you as being an agent of that brokerage, okay? Now, you can be an independent contractor or as an employee, whatever you and your broker agree that you will be. Providing all affiliated licensees with written policies and procedures under which they are expected to operate. Reviewing for compliance with the law and rules all listing contracts, leases, sales contracts, and management agreements within 30 days of the offer or contract. So when you're having that meeting with your broker and you're signing your agreements with them, your affiliated business agreement, placing or hanging your license with that brokerage, these are the things that should actually be discussed at that meeting. Of course, they may cover, you may go through an orientation where they cover the policies and procedures of the brokerage. One thing that comes to mind that I hear often from agents, whether or not the broker practices dual agency, where they will allow them to be on both sides of the transaction. That would be a policy of the brokerage that you hang your license with. So that would be a conversation or one of the things that the broker would go over with you at your meeting where you're signing your affiliation agreement. They will also review compliance with the law and all rules regarding listing contracts, leases, sales contracts, and management agreements. They will tell you what their process is for handling when you get an offer, when you get earnest money, what to do with your contracts, and so on. Having brokerage firm management reasonably available on a continual basis to assist licensee and the public with transactional business. Well, that's important for me, and it should be equally important for you as a future real estate agents. Who do I contact at the brokerage firm? Who will be reasonably available for me as a new agent? Who's my first phone call to when I'm stuck or I'm put into a situation that I don't understand, or my buyer or seller has questions that I'm not sure about the answer? So reasonably available should be important to you as a real estate agent. Providing reasonable safekeeping of all required records for real estate transactions. I would want to know that. Mr. Broker or Miss Broker, do you safely keep all real estate transactions? Is it okay for me to keep said transactions as well, all documents related to the transaction? If I needed to come and look at a transaction, where would those files be? Will I have access to those files to look at past transactions of mine? Making sure that only properly licensed affiliates perform activities that require licensure, and that any unlicensed assistant or office personnel be limited to administrative activities. Well, unlicensed assistants can't do the same things that a licensed agent can. A licensed agent, they're the expert, right? They can negotiate, they can write contracts, they can do everything that they're allowed to do under the letter of the law. Unlicensed assistants can't do most of the things that licensed agents do, but they can do things like file those records, your sales contract. They can answer the phone. They can be present at open houses as assistants. They can do administrative work. They can create your flyers for your marketing. They can even take your calls if you're going out of town or out of the country and won't be available. They can possibly take your calls. You can figure out a way to send your calls from your buyers or your sellers so that someone would be available to talk to, not as another agent, to answer some of their questions. Real estate assistant support personnel. A brokerage firm and a licensee affiliate employing unlicensed assistants are reasonable for the acts of those assistants. There must be a three-way written agreement among the broker, the affiliate licensee, and the unlicensed support personnel stating the duties that assistant and their compensation, which may not be paid in the form of a commission, but paid as a salary or hourly wage. For example, let's say I'm a very busy real estate agent. I'm just so busy. My phones are ringing off the hook. I have all of these contracts. I have all of these offers. I'm maintaining 5 listings or 10 listings at a time, and I need help. Well, I can hire an unlicensed assistant, okay? I need to consult with my broker because you should be consulting with your broker in just about everything that you do as a licensed real estate agent when your license is hung with that brokerage. So, we can come up with a contract that the broker, myself, the licensee, as well as the unlicensed support person, we can create a contract that states what our duties are, what the assistant can and cannot do, what the assistant will be paid, and how they will be paid. Activities allowed by unlicensed support personnel are only ministerial, which do not require discretion or the exercise of personal judgments on their part, and may include but not limited to the following. And there's quite a few things that an unlicensed person can do. Answering phones, forwarding calls and emails to licensee, securing public documents, assembling documents for closings, recording and depositing trust funds, placing ads from the brokerage firm's licensee in the media, acting as a courier for delivering or obtaining documents and keys, arranging dates and times for inspections, performing physical maintenance on real estate, accompanying a licensee to an open house or an appointment for security purposes. Okay, so that's the list of what an unlicensed person can do. Activities acceptable for licensed assistants, but not accepted for unlicensed support personnel to perform, might include these things: contacting public or making cold calls to secure prospects for real estate transactions. That's a no-no, because that's handling real estate business. Okay, hosting open houses. Only licensed agents can host open houses. Can the assistant be there to help make sure things are tidy, that we have flyers, that we have hors d'oeuvres, that to handle emergencies, okay? Showing real property to firms, customers, or clients. Big no-no. An unlicensed person should not show property. Answering questions related to brokerage engagements or sales transactions. An unlicensed person should not answer any questions about brokerage engagements. If the unlicensed person answers the phone, let's say they answer the phone for the brokerage, and you have a client that calls and she says, I signed an agreement with my agent that works at this brokerage and I agreed to give her 3% commission. But after talking to some friends, I don't want to give her 3%. I would rather give her 2%. Can you make that change for me? No, I can't. You would need to direct her to her agent or to the broker. Okay? You cannot discuss any brokerage related information related to contracts or sales transactions. Discussing terms and conditions of contractual agreements. Again, that's a big no-no. You cannot discuss terms Commission would be a term. Start and end date, the end date for a listing agreement. I signed it for 90 days, but I changed my mind. I want it to be listed for 60. Can you make that change for me? No, you need to contact your agent. Providing advice, suggestions, or recommendations related to real property or ongoing transactions. No, you clearly direct them to the agent that they're working with, or you can even, connect them to the broker, okay? Qualifying broker may assume liability for licensed affiliates, violations of license law, commission rules, unless broker can demonstrate the following. Broker had reasonable procedures in place for supervising actions of affiliates. Broker did not participate in violation. Broker did not ratify the violation, which means the broker did not give any consent for the violation. So while the broker is responsible for the licensee's actions, there are things or ways that the broker can kind of clear themselves if any of these things are in place. Brokerage firms operating in multiple locations. In each location, broker must comply with all local business ordinances. Local governments may charge a business license to a broker who maintains a physical office in that area. Where brokers engage in real estate transactions outside of counties where they maintain an office location, they may be charged by county a gross receipt tax on such transactions. You have to know that, the government, the counties, the local municipalities, they're going to look for tax related to certain transactions. When brokerage firm location changes, real estate commission must be notified within 30 days of any new address. So if your broker decides to move, the commission must be notified within 30 days with the new information.